against the private criminal charges that were brought against Mr. Keith Lowenfield. You remember they were brought by Mr. Morian, and I can't remember who the other defendant was. Well, this morning the DPP withdrew those charges, the private criminal charges against Mr. Lowenfield. So the charges that he faces now are just the charges that the police instituted. A date has been given, forgive me for not recalling what date that is. So the only matters he faces. Mr. Lowenfield also had matters in Court 3 before Magistrate Cheryl Isaac, in which case, those were cases brought by the police, it was disclosed that there were 6 persons who the Director of Public Prosecutions gave the fiat to prosecute. Sanjeev Dattadin, Glenn Hanneman, Ganesh Hira, Mr. Gosai, George Thomas, and Mark Conway were the 6 people. We have not been provided with a copy of the fiat, but the court was kind enough to share it with us. We immediately, upon seeing the fiat, objected to Mr. Sanjeev Dattadin being in charge of the prosecution. Mr. Hanneman indicated that Mr. Dattadin would have been in charge of the prosecution. The basis for that objection was very simply this. Mr. Dattadin is a sitting MP for the government, People's Progressive Party, and to give him the responsibility for the prosecution of a matter which is highly political in nature, and which Mr. Hanneman agreed had political consequences, we believe is a poor exercise of her discretion, but more importantly and more fundamentally, all prosecutors have a responsibility for fairness. They have no interest in conviction, they have a responsibility for fairness. Part of that responsibility is that they must bring all the information to the court, whether it's in favor of their case or against their case. The Legal Practitioners Act, as a specific requirement, says that all prosecutors have an obligation to be dispassionate. We believe that the appointment of a sitting government MP as a prosecutor completely violates all of those and has the appearance of bias, because a person who clearly is on the opposite side of the political fence or clearly is advocating a position that is hostile to the defendant ought not to be vested with this power. So we have taken that point, and more fundamentally we have argued, and we are arguing, that Mr. Lowenfield's ability to get a fair trial depends on the prosecution acting fairly and in an open matter. One of their obligations is to disclose any information that they have in their presence which may be in favor of the accused person. We believe to the onlooker, which is the test that has been established in all the cases, that to the average onlooker who observes this, they will not believe that if Mr. Dattadin or any prosecutor who has a political bias comes across information that is in favor of an accused person, that they will share that information. And therefore we believe Mr. Lowenfield's right to a fair trial has been adversely impaired. We've invited the court to consider this, and we certainly will be taking further steps in relation to this. The court ordered us to put over our submissions in writing, and we come back in 3 weeks. The other issue was the prosecution asked for a summary disposal of the matter. That means they wanted the matter to be heard completely in the magistrate's court. We opposed this application on the basis that the allegation against Mr. Lowenfield, and all of this applies to Ms. Myers as well, I'll come to her in a minute, is that he defrauded the people of Guyana. There are 750,000 people in Guyana. You don't get an allegation of a criminal act that has more victims. And therefore, we believe that a person who you accuse of defrauding 750,000 people should face those 750,000 people in the shape and form of a jury of 12 persons of their own. So we want us to have a jury trial so that Ms. Myers and Mr. Lowenfield can face their own in the jury. The prosecution were arguing that amongst the arguments that they put forward was that they thought the matter was too complex for a jury. Of course, we thought that was a spacious argument because, of course, judges direct juries. They were saying it would be easier to have the case heard in the magistrate's court. The court, of course, has invited submissions on that, which we do, and we come back sometime late in November. In the case of Ms. Myers, again, we took the same objection in relation to Mr. Dattadin because he also is either part of or responsible for the prosecution of Ms. Myers, and we, for the same reasons that I previously advanced to you, those objections were taken. Again, we oppose a summary trial for the reasons that I indicated, and the court has ordered that we lay over our written submissions on that matter, which we will do, and we also come back at some future date, which at the present moment escapes me as well. I don't know.
We should probably put on the record concerning Mr. Louisfield as well that we've requested comprehensive disclosure in the Fifth Court matters, and today was slated for disclosure in those matters, and having come here today for disclosure, those matters
What, the private criminal?
That's a private criminal charge.
Okay.
Those matters were withdrawn.
So it's very interesting. The private criminal charges that were brought at the start, that was the first set of charges you remember, that were brought against Mr. Lowenfield, upon which he went on $400,000, $500,000, $600,000 bail, which they were alleging was so serious. They were opposing bail for Mr. Lowenfield. The trial for those matters is scheduled to begin on Monday, and they come today on Friday, and they withdrew those charges. They withdrew those charges. So they clearly, as we had said at the start of that trial, were not in a position to commence them. They clearly realized that they were not in a position to commence them. And the Director of Public Prosecutions, after our invitation several months ago to review them and withdraw the charges, has waited until the matter is about to start to withdraw the charges. So I don't need to comment on that. That speaks for itself. I believe that speaks for itself.
We should also disclose Mr. Dattidin's characterization of the matters against Ms. Myers.
We heard the most amazing, interesting statement today. So when we were asking for an indictable trial, Mr. Dattidin, in his submissions to the court, said that Ms. Myers' matter is a simple matter. Now, you will recall that Ms. Myers was in custody for 3 nights at the Better-for-Acting police station. I can't imagine the prosecution characterizing her case today as a simple matter. After, she said it's a very simple criminal charge, after somebody has spent 3 days in custody with her specific medical condition, to come and treat with it in that manner, I think speaks volumes. And again, I leave you to look at the facts as I've related. No opinion from me.